but I think I'm okay since I'm wearing the same shirt and tie combination I wore a couple days ago. If you're watching us on Facebook, you can know my wardrobe habits and how sometimes I recycle shirts. I wear them 2 days, and bow ties, I'll just keep the same bow tie so I don't have to make a fresh decision about being the smartest guy with a bow tie in Chattanooga. Best it be a colorful and an appropriate one rather than a clownish one, as my wife sometimes accuses me of doing. David Tulis here at 92.7. We cover local economy and the free market in Chattanooga and beyond. And we're talking with a paralegal and activist and researcher in statute. He has a wonderful life of just being able to read statute and analyze and explore and read cases. And he has a special for you. And I want to just have him tell you what it is, but it is a special offer just for you. And it is regarding let's see, we're talking with Dave Myrland. And Dave, what is it you want my listener to have? It's a download he can get from your website, and it contains 90 highlighted cases. And the cases make what point, Dave Myrland?
Okay, here we go. I need to back up for just a second. Einstein said the hardest thing in the world to understand is the income tax. And I did that. I've explained it. It's a piece of cake in a couple of ways that are profound. But Einstein also, and I heard this, I haven't verified it, he also had 5 identical suits in his closet so that he didn't have to waste time choosing clothes. So you have a direct tie to Einstein in your in the way you manage your attire for your appearances.
I'm trying.
At the bottom of this motor vehicle code argument, the reason I say orient yourself on statute first, and I really wanted to wrap up the conversation before the break with this point. In Washington State, on wevgov.com, you'll see on the motor vehicle code page a review of Washington State law that I suspect is structured identically to what you're going to find in a lot of states. In 1915 through 1921, there was a very specific definition of motor vehicle, and it only applied to those engaged in commerce on the highway. And thereafter, the law was never broadened to apply to other subjects. There. Now you have a law that was never written to apply to me when all I'm doing is going to the store in my automobile, yet they apply it to me. That's the single best argument to have. This law doesn't apply to me. Case dismissed. I studied why cases get dismissed. I don't want to study why the government's able to kick somebody in the behind. I want to study how somebody kicks the government in the behind. And I studied a bunch. And so when I see a case go in a certain direction, or I know there's a direction I can push a case to make it dismissible, I do it. So now the freebie for your audience, there's 2 freebies. Both of them begin with wevgov.com/.
We, W-E-V, as in Victor,
we
gov.
Government. wevgov.com/. And there's 2 freebies. Both of them are zip files. This is all lowercase, no spaces. Murdoch.zip, MURDOCK.zip, and association.zip. Association.zip is a bunch of cases that say you have the right against forced association. And I say, well, I got a right against forced contract and a right against forced enjoyment of property too. All my constitutional rights are mine. You can't force me to exercise them. So the forced association argument is already mature, and he made that argument, and the judge reflected upon it. That is profound. That's a big one. It should have been argued against the health care bill. You have to associate with an insurance group. You have to enjoy your property. You have to form a contract. No, I don't. So all these should have been argued against the health care bill, and this is the first time in years I've heard this crop up, except in the Supreme Court case that's up now, where they're arguing they don't want to associate with the gay customers that came in and wanted them to bake a cake. And so they're making not really exactly on point, but they're making a forced association argument. Now, the Hirsch case, and I feel that if you're making a right to travel argument, it's always good to have a judge speaking for you. And when you look at, and the judge didn't mention this decision, I presume that the guy didn't know to cite this decision, but it's the decision of Buck versus Kuykendall, 1925 U.S. Supreme Court. And it says a citizen may have a 14th Amendment right to transport his property on the highway. And people that use the highway as a place of business don't have that right. It's very clear, but they don't pronounce it because it wasn't up for decision in the case. But the Supreme Court reached out and said, a citizen may have, it's like you want to give them a bullhorn or something, they're telling you it's not up for issue in this case, but a citizen may have a 14th Amendment right. And so there's the Supreme Court arguing that, attention, you might have a right here, and it hasn't been. That's what everybody keeps arguing, and I argue statute instead because it constrains their authority, and so my right to travel is just a collateral benefit instead of a key argument, and that's the benefit of arguing statute. So now, in the Hirsch decision, it's significant for that reason. The right to travel is important. He needs to argue it much better. And I have my stuff in Microsoft Word. He's welcome to it. I don't want to see this opportunity squandered. So go research the Tennessee Motor Vehicle Code early on and put it on the record if you find constraining language about the scope of the statutory scheme at the Motor Vehicle Code, and put it on record, and that forces the other side to come through with a law that says we, the legislature, intend to broaden the scope of this statute to include those who are traveling, where we did not include them in the original act. That's what you have to identify in the law after you find constraining language one year. Well, where did it get broadened? Where did the legislature say you can do this? It shifts the burden. Instead of arguing for a right, that doesn't shift the burden. It gives the judge all the room in the world to say, well, other people have come before the court before, and we have decided this way, and it's pretty much frivolous at this point. It's a shibboleth, and we don't want to hear it again. It's important to have your feet on the ground first, and I'd like to help the guy. Now, in this Hirsch decision, and you're eager to get on to another topic, I can't tell you how big this is, Dave. I can't overstress. I don't want to come out on the air and say this is it. But I have a lot of talent when it comes to interpreting statutes.
Why is this a big case? Why does it matter for my listener?
In the chart, go ahead.
I'm asking why does this case matter? Why is it important for my listener, Dave Myrland, paralegal and legal researcher? Who cares?
Because you do have the right to travel, but I argue for a statutory constraint on their authority, saying they can't talk to me. The law they're using only applies to those engaged in commerce. And that shifts the burden because I'm using a statute instead of arguing a right. And so you're arguing, importantly, that you have a right to travel, which a lot of cases support, but we know the courts won't honor them. They're making money off the Motor Vehicle Code, and there's no stopping them. And so you have to argue statute and say, I have a statute here that does not apply to me. When was it broadened? Right there, you shifted the burden. They have to go on record with a statutory analysis, and I'll bet you they don't have one. So that's another reason this is important, is that you're using just the law to argue it that way. And I'm not the one that said this was real important. I said what I have to say about the case is very important. I think he'll have very, very little success, no matter how well he argues it. But if he wants to be heard by the U.S. Supreme Court, ultimately, he has to reduce it to a statutory argument. So, can I tell you what I found in the charging statute real quick before we move on to tax?
Is that on the gun law in this case, or which statute?
Yes, the gun law.
Okay, so Jay Hirsch was convicted.
Tennessee statute, revised code 39-17-1307, the charging statute. A1, a person commits an offense who carries with the intent to go armed a firearm or club. Pretty hard to get out of that. He was carrying a loaded weapon in a cooler right beside him on the seat. But 922 of Title 18 is about gun crimes, federal. 922G. 922G3 says if you own a gun at home and you're out and about and you smoke a joint, it's a federal crime. When it says it shall be unlawful for any person who is an unlawful user of or an addicted to any controlled substance. And so any person that owns a gun who is an unlawful user of a drug. So G, 922G is about who is not allowed under federal law to possess a firearm. And so the reason I point to that is because in the charging statute, Tennessee law, which I just cited to you, we have subsection E1. It is an exception to the application of subsection A, that a person, hold it, what? Yeah, there's an exception to subsection A that they charged him under. A says a person commits offense who carries a concealed weapon. And E1 says it is an exception to the application of subsection A that a person is carrying or possessing a firearm or ammunition in a motor vehicle if the person, A, is not prohibited from possessing under 18 U.S.C. 922G.
Well,
so
this what you're looking. Okay, hold on, Dave Myrland. What you're looking at is a revision in the law. Jay Hirsch was charged before the carry the gun in the car rule went into effect. In fact, just a few days before that law took effect, he was accused. So he's being accused under the former statute.
Oh,
so, yeah, it's.
I can't discern that from reading the brief.
Okay.
Missed me by this much.
All right, well, go ahead.
TV
Pass
star
on.
said that. Don Adams, get smart. Anyway, c'est la vie, because it's a huge one. I thought and if it existed before he was charged, I would have found the Holy Grail. But that shoots a hole in that one, doesn't it?
Go ahead. What else is on your mind, Dave Myrland, about the Hirsch case? I wanted to pass on. We have just about 10 minutes. What final point can you make about the Jay Hirsch case in Tennessee, which is the biggest in 80 years?
Term intent to go armed, I've never heard that before. And it's not defined in the charging statute. And I feel that should be made as a constitutional challenge, because that's a jurisdictional challenge, and that can be made at any level. You can make it for the first time on appeal. And I would research the beginning of your motor vehicle code in Tennessee to see if it has those constraining statutory terms in the beginning like Washington State does. And I'll bet you'll find that that's the case. It originally only applied to commerce for the great big battery-operated electric trucks that weighed tons that were delivering the first goods in town. And beyond that, it hasn't been broadened. So that's what to remember for that. And
because the word motor refers to those electric motors, not engines.
That's right.
Cars now don't have motors; they have engines, which are gasoline or diesel fueled.
Exactly.
Well, Dave Myrland, you're a tax expert. What I want to get to the question about wages. My listener thinks that because he thinks that wages are taxable, he's told that, and the union movement agrees that wages are in fact a profit. That from the first hour of your work, the money coming to you in the way of wages is profit, and not half of a trade. The trade being the labor. Let's say my listeners pay $20 an hour. He gives an hour of labor and he's paid $20. There's no profit, I would argue, in that, because it's an equal exchange. His pay he's paid exactly what he's worth at $20 an hour, no more. And so there's no profit to be made by having that little bit of excess, which is the leftover after all the expenses are deducted. What is happening in the courts of appeal that of which you are aware or involved, Dave Myrland?
Well, there's two different compartments that you just identified and spoke fluently about as if they were one. One is, how do I determine the fair market value of property? And the other one is, what does the law say my cost is? Those were two different topics that are embraced within the discussion you just had for the introduction here. Now, everybody can say what they want about wages being income, which is profit. Income and profit are synonyms. They can say all that matters is what the law says. And so I don't care what the unions say, and I don't care what previous case law says if the case law is not about the statutes that explain how to tax me. So I first put the court on footing it hasn't been on before. Everybody argues in the government, and I'm talking about the government's best tax attorneys. I've written against them for years. They know all about me. And I have arguments that are unique to me. I did more research than anybody else into the tax code, and I came up with much different conclusions about a myriad of very broad. I trade my labor for the money that my employer has, that my customer has, self-employed or employee, whatever. I sell my services. What I receive is either a cost or a profit, and it depends only on the law. The law, Section 83A of the tax code, says only the excess over the amount paid is gross income. And the amount paid is defined as the value of any money or property that I paid. Any is all inclusive. All the courts agree. The government won in the Supreme Court 5 times arguing that the term any is all inclusive. So any property is a cost, labor is property, and so labor is my cost. When it comes to a tax return, I can't write down labor for a deduction. I have to put a figure on that line. The fair market value of property is determined through the terms of an arm's length transaction, set of a transaction negotiated between two unrelated parties acting in their own best interest under no compulsion to buy or sell, all relevant facts disclosed. Black's Law Dictionary, 6th edition, page 109, arm's length transaction, 1973 Supreme Court, U.S. versus Cartwright, on and on. So I know what my client is willing to pay me for the breakfast I make for him in my diner, or for the tax return I prepare for him when I work for H&R Block. Whatever my client pays me, or my employer pays me to drive rivets in this piece of the Boeing 747 that they make in Seattle, or my employer pays me to work as a tech on the Alaska pipeline oil pipeline, or I'm paid to down the street to operate the cash register at the grocery store. Whatever my employer or my client, my customer, agree to pay me for my services, since they are unrelated and they don't have to buy my services and I don't have to sell them, we've established the fair market value. If you want to pay me $35 an hour to be a welder in downtown Seattle down at Todd Shipyards, that's one thing. But if you want me to trek up to the pipeline in Alaska and live on the tundra and weld, you're not going to pay me $35 an hour. I'm going to make a lot more than that off of you. And so the market sets the price. That's called free enterprise. We're all very familiar with it. And it comes into play in exactly this way. If all property is a cost, I can't deduct labor. I have to deduct a figure. What did I get in exchange for my labor? I got a gold watch. I got a company parking spot. I got a per diem lunch paid when I got went out of town on business for the company. I got a wage, a salary, a tip, a commission, whatever I got in association with the performance of my services, unless it's a bonus that I didn't contract for. It's the cost, or it's the value of what I paid for my paycheck. And they can't get out of the argument, only except for one way. They say, you did not buy your labor before you sold it, and so everything you received was a profit. And my argument in the 90s, 5 times all the way to the Supreme Court, was, where's your authority to exclude labor from any money or property? And they penalize you for asking. Well, now I've got all these Supreme Court cases that say the term any is all-inclusive. So the one way they weaseled out of the argument, I can now slam the door on. And that I have going to the Supreme Court as soon as the 9th and 11th Circuits have rendered their decisions. We're waiting. The exchange of briefs is over. And then we're in the Supreme Court with 2 tax cases on more findings than just this. There's a very interesting challenge we're making to Tax Code Section 7345, a new statute, where if you have a controversy of $50,000 or more and you're not on a payment plan with the IRS, you got a lien and levy in place, you can't get a passport. So we're challenging that because you can't get a review of Section 83, and they're going to take away a substantial right while you can't review the law that governs whether or not you owe a dime. So we're challenging the statute as unconstitutional because the procedures or the lack of review deprives you of the right of procedural due process.
This is David Tulis, and Dave, hang on just a second. Dave, here's the question that we want Dave Myrland to answer.
Section 83 argument on the website on the left at the top of the menu column. You'll have a link that says YouTube 2. Click on YouTube 2. You'll have a tutorial on my YouTube page about Section 83 as well, 2.5 hours long. Go ahead,
Dave Myrland, we have just a minute here. Let me just get a summary of what you're saying. You're saying that in the federal law, the statute, the word any is telling the listener that if he has wages, they're not taxable as income because they are an equal exchange. Is that what you're saying the law allows, and you're defending that in court in cases on appeal out of tax court? Is that what you're saying?
I'm saying I've been deprived of the provisions of Section 83, or you couldn't tax my pay. Section 83 says only the excess over the amount paid is gross income, but the government says everything's gross income.
Right. You're taxable for the
excess
first
over
dollar.
The amount paid, that's the profit over the cost, isn't it? And the amount paid is defined as the value of any property. Any is all-inclusive. Labor is property. Its value is what I received. I'm going to keep all of that from being included in gross income, or I have to violate Section 83.
Okay, we're talking with Dave Myrland, and let me just let the listener know, if you go, he's making you an offer, and the offer is at wevgov.com. That's wevgov.com. There are 2 files that talk about matters we've raised today, and it's /murdoch.zip, and there are 90 court cases that he has highlighted with highlighters showing you important things that matter to you, and also wevgov.com/association.zip. Look there, and that is about the right of association, that you can't be compelled to have insurance on account of that right, repeatedly given in high court cases. Dave Myrland, thank you very much.
My last point about the Hearst decision.
Well, we're gonna have to save that for the next conversation.
Criminal intent. He didn't have criminal intent. It's obvious from the decision.
Great point. No criminal intent. Dave Myrland, thank you so much for joining us. This is David Tulis, and we've just been hearing from Dave Myrland, and we're brought to you by Nooganomics.com. Nooganomics.com, the website for the man who matters. I do thank you for joining us. And now some important announcements. Support our sponsors, David Tulis.
The Tennessee Valley's news talk leader, Nooga Radio, digital